If an attorney calls your filings frivolous in open court without providing supporting evidence, here are a few effective ways you can respond. 1. Request specifics and clarification. Politely request that the attorney clarify or substantiate their claim. You could say, "Your Honor, I would like to request that counsel clarify what specific legal or factual grounds they believe make my filings frivolous. Unsupported allegations should not be allowed to diminish the integrity of this proceeding." This forces the opposing attorney to either back up their statement with evidence or retract it. 2. Cite the lack of evidence. Highlight that the opposing counsel has made an unsupported assertion. You can point out the absence of evidence and the importance of factual basis. "Your Honor, opposing counsel has characterized my filings as frivolous, but has provided no supporting evidence or legal basis for such a claim. I respectfully submit that allegations without substance should not be entertained by this court, especially when the filings are grounded in law and fact." This demonstrates that you are holding the attorney accountable for making baseless claims and positions your filings as legitimate. 3. Reference legal standards for frivolous filings. Cite legal standards that define what constitutes a frivolous filing. Courts typically consider a filing frivolous if it has no legal merit, is not grounded in fact, or is brought for an improper purpose. You can say, "Your Honor, under the legal standard for frivolous filings, a filing must lack a reasonable basis in law or fact to be deemed frivolous. My filings clearly address and insert relevant facts or legal points which directly respond to the issues in this case. Counsel has failed to demonstrate how my filings fail to meet these standards. This directly counters the accusation by referencing the appropriate standard and reinforcing the legitimacy of your filings." 4. Request the court to strike or disregard the remark. If the opposing attorney persists without providing any substantiation, you could request that the court strike the remark from the record. "Your Honor, given that counsel has failed to provide any evidence or basis for their allegation, I respectfully request that the court disregard or strike the comment as it is unfounded and irrelevant to the matter at hand." This approach aims to mitigate any potential negative impact the unsupported accusation may have on the court's perception of your filings. 5. Preemptively address potential weak points in your filings. If you suspect the opposing attorney might make such claims again, be proactive in demonstrating that your filings are grounded in fact and law by citing relevant statutes or precedents, showing that your filings have merit. You could also preemptively mention that unsupported claims should be disregarded. By taking any of these approaches, you assertively challenge the opposing attorney's statement, redirect the focus to the merits of your filings, and maintain a professional stance in court. If you prefer a more aggressive and stern approach to hold opposing counsel accountable for bad faith behavior, you can take the following steps to directly challenge their conduct and invoke legal consequences for their actions. 1. Assert bad faith and misconduct. Begin by making it clear that counsel's statement is not just unsupported, but constitutes bad faith and misconduct under the law. You can directly address the judge and reference specific rules governing attorney conduct. "Your Honor, opposing counsel's accusation that my filings are frivolous without providing any factual or legal support is not only baseless, but also a clear violation of their professional duty of candor under specific rule or statute, such as Georgia Rule of Professional Conduct 3.1, which prohibits making unsupported claims for the purpose of harassment or delay. This is a textbook example of bad faith litigation tactics, and I formally request that the court take appropriate action against counsel for attempting to mislead the court and undermine the judicial process. This places opposing counsel on notice that their conduct violates professional standards and demands action. Have 2. Motion for sanctions. You can request immediate sanctions under the appropriate rules of procedure, which allow courts to penalize frivolous or bad faith behavior. Courts do not take lightly to accusations of frivolous filings without evidence, so you can move the court to impose sanctions on opposing counsel. Your Honor, I am requesting that this court impose sanctions under refer to rule, e.g., Georgia Civil Procedure Rule 11, for counsel's reckless and unsupported allegation. Not only does opposing counsel fail to provide a factual or legal basis for their claim, but this is a deliberate attempt to obstruct justice and mislead this court. The rules provide for sanctions when such conduct occurs, and I respectfully urge the court to take immediate corrective action. By referencing Rule 11 or equivalent in your jurisdiction, you are invoking the legal mechanism designed to punish baseless claims. 3. Demand accountability via ethical violations. Hold counsel accountable by making a record of their ethical violations and demand that their misconduct be reported or that the court consider ethical violations as a basis for sanctions or further action. Additionally, Your Honor, counsel's actions today violate not only Rule 11, but also fundamental principles of professional conduct, including ABA Model Rule 3.3, which requires attorneys to act with candor before the court. I request that this behavior be formally noted on the record and referred to the appropriate disciplinary authority, as it clearly constitutes an ethical breach aimed at delaying and obstructing the legal process in bad faith. This escalates the issue beyond the courtroom and suggests that opposing counsel should face disciplinary action for their misconduct. Challenge counsel's credibility and intentions. Call into question counsel's overall intentions and credibility, suggesting that they are using these tactics as a shield for their lack of substantive legal arguments. Your Honor, it is evident that opposing counsel's baseless attack on my filings is an attempt to compensate for their own lack of legal grounds in this matter. This type of misconduct not only disrupts the fairness of these proceedings, but also seeks to abuse the court's time. I urge this court to see through this tactic and address it accordingly so that such egregious behavior is not tolerated in this court. This attack shifts the narrative to undermine opposing counsel's credibility while reinforcing your position. Number 5. Demand immediate action from the court. Close by demanding immediate corrective action from the court to deter such bad faith tactics from continuing. Your Honor, given the egregiousness of counsel's behavior, I respectfully demand that immediate action be taken to prevent any further abuse of the judicial process. Counsel's actions amount to nothing more than an attempt to intimidate and mislead, and the court should not allow these proceedings to be tarnished by bad faith tactics. I again move for sanctions and request that a strong precedent be set here today that this court will not tolerate such violations. This approach sets a firm boundary, calling for the court to immediately address and rectify opposing counsel's actions with appropriate consequences. By following this more aggressive approach, you actively hold opposing counsel accountable for their misconduct, leveraging the rules of professional conduct and procedural law to demand that bad faith behavior be penalized swiftly and effectively.